the Federal Constitution of Malaysia enshrines the right to freedom of religion. It ensures that all individuals have the liberty to profess, practice, and propagate their religion, subject to certain restrictions aimed at maintaining public order, health, and morality. This article guarantees that everyone can practice their faith without interference from the state or others. Although Islam is recognized as the official religion of Malaysia under Article 3 of the Federal Constitution, the Constitution also allows for the peaceful practice of other religions. This highlights Malaysia's effort to balance its identity as an Islamic state with its commitment to religious diversity. This situation is further complicated by Malaysia's dual court system, which includes both civil and Sharia courts, often leading to significant legal disputes and societal discussions. Malaysia's dual legal system brings additional complexity to cases involving interfaith issues and the conversation of minors. Such cases underscores the necessity for clear guidelines and a cohesive approach to ensure that the constitutional rights are consistently upheld. To sum up, Article 11 of the Federal Constitution of Malaysia is vital for protecting religious freedom, but its application, especially regarding children's religious status, remains a contentious and evolving issue.
The Federal Constitution of Malaysia guarantees freedom of religion under Article 11, allowing individuals to profess, practice, and propagate their faith. Even though it restricts the propagation of non-Islamic religions to Muslims, Malaysia's dual legal system comprising civil law under the Federal Court and Sharia law under the Sharia Court complicates this rights application. Article 11.4 allows state law to regulate religious activities among Muslims, emphasizing the delicate balance between federal oversight and state authority. This balance is crucial in maintaining justice and religious freedom within Malaysia's dual legal framework. The federal courts sometimes intervene to ensure constitutional protection are not undermined by Sharia jurisdiction. Issue of a child's religious status emerge when one parent converts to Islam, leading to jurisdictional conflicts and raising questions about a child's rights to choose their religions versus parental authority under Article 12. Critics argue this infringes on a child's autonomy, while proponents believe it protects their well-being, highlighting the tension between parental authority and the child's religious freedom.
So, I will talk about the fact of the cases. Indra Ghani married Pak Manatan under the Law Reform Marriage and Divorce, and after that, they had 3 children. In 2009, Pak Manatan converted to Islam and changed his name to Muhammad Ridwan Abdullah, and he also converted their 3 children to Islam without Indra's knowledge or consent. So, for the certificate of conversion, Indra received 3 certificate of conversions and a document showing that the children were registered as Muslim by the Register of Mu'alaf. But the children were not present before the register and did not receive the required clauses of the affirmation of faith as per the Perak enactment. So for the legal proceeding, High Court 2010, Indra successfully challenged the conversions, squashing the certificate. She was granted custody of the children and her divorce was allowed. Court appeal, the order from the High Court was set aside, but the appeal Indra aggrieved by the court appeal decision appeal. So next in the case, the lawsuit is not about first one, conversion validity, because Indra is not questioning the conversion itself but the process and legality of the conversion, and focus on whether the Register of Mu'alaf comply with the Perak state laws when they're registering and issuing the conversion certificate for her children. Second, children's status. The lawsuit is not about the children's status as Muslim convert. It challenges the legality and constitutionality of the Register of Mu'alaf administrative action in exercising his power. And the last one is Islamic law. The lawsuit is also not address the question of Islamic laws and practice. It does not involve the interpreting any Islamic personal laws or principle. In other words, the focus is on the whether the procedure and the legal requirement for changing the religion of Indra's children were properly followed, not on the religious aspect.
I will talk about the lawsuit is about. Okay, actually the federal court has examined the three key questions of this lawsuit. First, about jurisdiction of civil versus Sharia courts, whether the civil courts have exclusive jurisdiction to review actions of public authorities, like the Registrar of Mu'allaf. Okay, the answer is yes, because the civil courts have the powers to review a public authority's action is a basic part of the federal constitution that cannot be removed and cannot be transferred to Sharia courts. Civil courts have constitutional protection of judicial independence, but Sharia courts do not have the same power and cannot be given such power. So let's talk about the civil courts. Based on the Federal Constitution, Article 1211 vests judicial powers exclusively in the civil courts. Judicial powers, including judicial review of the public authorities' actions and decisions, cannot be removed from the civil courts and cannot be given to any other body who do not have the same level of constitutional protection as civil judge to safeguard their independence. Unlike the civil courts that are established in the federal constitution, Sharia courts only come into existence when the legislatures make state laws to establish them. Now, so let's talk about Sharia courts jurisdiction. Okay, Sharia courts jurisdiction are limited because Sharia courts cannot exercise the civil courts inherent judicial powers, including the power of judicial review. Also, Sharia courts are two Muslim and Islamic laws, personal and family laws for Muslim. Or can we say that Sharia courts only for private law and not for constitutional law? For this case, Indira as a non-Muslim has no legal standing to appear before the Sharia courts, and the Sharia courts also not have the jurisdiction of a non-Muslim. The Sharia courts do not have the power to expand its own jurisdiction to choose to hear to Indira's case. On Federal Constitution, Article 1211A does not grant Sharia courts exclusive jurisdiction over all matters of Islamic law. And that is simplistic to say that Sharia courts must have sole jurisdiction over matters of conversion as it involves Islamic law and practice. Next, the second question is about legal requirement for conversion. The question is, must a child from a non-Muslim marriage comply with the state law requirements before conversion to Islam is registered? The answer is yes. Indira's children did not meet the requirements of the FERA Enactment 2004, which not uttering the affirmation of faith. Okay, so what is the FERA Enactment 204 that relevant in this case? The enactment is about section 96(1), which requires the person converting to say in Arabic the two clauses of the affirmation of faith out of their own free will and with understanding of the meaning for a valid conversion to Islam. And also the section 106B, which says a child may convert if he is of sound mind and his parent or guardian consents in writing. In this case, Indira's children not present before the registrar and did not utter the affirmation of faith as required under the FERA state law. At the time of conversion, the children age were 11, 10 and 11 months years old. The legal requirements under section 96 and 106B were not fulfilled and not complied with. The registrar exceeded his authority by issuing conversion certificate without fulfilling legal requirements. So, the last question is about parental consent for child's conversion. The question is, must both parents consent before a child from a civil marriage can be issued a conversion certificate? The answer is yes. Both parents' consent is required under Article 12(4) of the Federal Constitution and the Guardianship of Infants Act GIA. Federal Constitution Article 12(4) is about a parent or guardian shall decide the religion of a person under the age of 18 for matters such as religious instruction. Consent must be from both parents for best interest of the child, who will be subject to new and different set personal laws when the religion is changed. Guardianship of Infants Act GIA that relevant here is Section 5, which provides for equal rights of both parents in the custody and upbringing of their children. And also the Section 11, which requires the courts to consider the wishes of both parents. On whether GIA provisions which do not apply to Muslim unless adopted by state laws apply to Indira's case, because Muhammad Ridwan is now a Muslim. His conversion to Islam does not change the legal position before his conversion, and the provisions still apply to their children from their Hindu marriage. This is in parallel to the situation where a person is a civil marriage under the law reform, which is a Marriage and Divorce Act, remains bound to legal obligations under this act even after converting to Islam, which can be said that legal obligations under a civil marriage continue even if one spouse converts to Islam. Judges' agreement, the federal court's decision was supported by 4 other judges, which is Court of Appeal President Tan Sri Zulkifli Ahmad Makinuddin, Chief Judge of Sabah and Sarawak, Tan Sri Richard Malanjun, Federal Court Judges Tan Sri Abu Samanuddin, and Tan Sri Ramli Ali. That's all from me. Thank you.
In conclusion, Article 11 of the Federal Constitution of Malaysia is essential for ensuring religious freedom, but its application, particularly regarding the religious status of children, remains complex and contentious. Cases like Indira Gandhi's highlight the need for ongoing legal clarity and societal dialogue to balance individual rights, parental authority, and religious diversity. Ensuring these principles are upheld is crucial for maintaining harmony and justice in Malaysia's multi-religious society.